The defense catches you on video doing your daily activities. Can they use that video at the time of trial? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury trial attorney practicing law here in the state of New York. Most of the time they will want to capture you on video, on surveillance video, secret video, to show to the jury that you could do things that you claimed at your deposition in sworn testimony that you claimed you couldn't do. For example, if you are asked questions at your deposition, which by the way is a question and answer session given under oath prior to trial. Now, if you're asked questions, can you play basketball? And you say, no, I can't. Can you go rock climbing? No. Can you do hiking? No. What activities can't you do today? And now you give a whole laundry list of things you cannot do. And then shortly afterwards, they capture you on video doing those exact things. Well, if that's really what happens, you've got more problems than I can begin to tell you about, and your case is going right downhill, among other big problems. But the reality is that if they capture you doing those daily activities that you claim you can do, walking to your car, going to pick up your kids, going to the grocery store, and all those other daily activities that we do normally, can they use that video to show at trial that you're able to do so many different things? The answer is they may be able to. They may be able to argue to the jury, hey, look at this person isn't that badly harmed. They now are able to do so many different activities. And that they may be able to use in order to rebut the argument that you suffered a significant injury that prevents you from doing many of your daily activities. Now, the key question obviously is there anything contradictory between what they caught you doing on video with what you have testified with in the past? If there's nothing contradictory, what we then do is we now use that video at trial, the defense's surveillance video, and we argue to the jury the following. Ladies and gentlemen, you heard from my client explain to you what happens behind closed doors. The defense didn't get a camera into her bedroom when she takes off her clothes at night. They didn't show you how much difficulty she has going up and down stairs. They were unable to show you on video the difficulty she has stepping into the shower and things that she's unable to do. So what we then argue is that, listen, there are many things that the surveillance video doesn't show, and they didn't have an opportunity to even bother. You know why? Because they couldn't gain access inside to a private home. And so now we ask you, as the injured victim, to go ahead and explain to the jury all of those things that you're unable to do or do with difficulty. So why do I share this great information with you? I share it with you just to give you an insight and an understanding into what happens when the defense gets some secret surveillance video of you and how they might be able to use it at your trial involving a medical malpractice matter or even an accident matter. You know, I recognize you probably have questions of your own involving a medical malpractice, accident, or car accident matter. And if your matter happened here in the state of New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. This is something I do every single day. I answer questions just like yours, and I'd be happy to talk with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.